Hello, everyone, and welcome. This is On the Record, Maintaining Immigration Compliance for Your Organization. My name is Brittany Sagal. I'm the Director of Marketing for Envoy, and I actually have the wonderful task of introducing our two presenters today. First, we want to go over a few housekeeping items with everyone. So this session is being recorded, and we'll be sure to send you the recorded session for your reference or to share with others in your organization after the webinar today. We will definitely be leaving time at the end for questions following the presentation. So if you would like to ask a question, please use the question function on the right-hand side of your webinar screen. We'll get through as many as time allows, but certainly you can always post to the Communication Center if you have a question that we are unable to get to today. So let's get started. For those of you who don't know, Envoy is the leading immigration services provider. We combine legal expert representation with technology to provide the only enterprise platform that actually enables companies to effortlessly hire and manage their workforce across borders. So that's everything from navigating U.S. immigration to securing global work authorization and business visas to really tracking and managing all of your international employees. So we do that actually for over 1,000 companies across many industries, locations, and company sizes. We really understand that the immigration process can be frustrating, so we try and alleviate all of those pains for you. Wanted to go over the agenda briefly with everyone so we can look at what we're actually going to be presenting today. We're going to be looking at some recent enforcement trends. We know that compliance has been in the news a lot. There's a lot of questions surrounding what it actually means. We want to take those trends and really dissect them a little bit and give you some more information. We're also going to be looking at drafting corporate immigration policies. That's a question we receive a lot here. What are some best practices for doing that? Why is it important? We're going to cover that. We're also going to cover public access files. So this is a really popular topic for many, many people. And unfortunately, there are a lot of common mistakes that are made. We're going to give some best practices, advice, and tips to keep you secure and compliant. And then, of course, as I mentioned previously, we're going to be leaving some time for questions at the end. So again, if you have a question, please use the question function in the webinar app on the right-hand side of your screen. So without further ado, I'd like to introduce today's speakers. We have Allison Kranz and Sarah Maxwell with us today. Allison Kranz is an Immigration Solutions Partner for Envoy. Prior to joining Envoy, Allison practiced immigration law and was a managing attorney at Maney & Gordon, PA, and an associate attorney at Ogletree Dinkins. She represented Fortune 500 companies in business immigration matters and acquired critical experience in H1B, LTN, O, and permanent resident cases, as well as U.S. Department of Labor audits. So we're so excited that Allison has recently joined the team, and we couldn't be happier that she's on today's webinar with us. We also have Sarah Maxwell, who's the head of global for Envoy. So her experience includes handling corporate and employment-based immigration law, particularly in developing and executing global immigration policies for Fortune 500 companies. She has counseled multinational companies and corporations on the movement of personnel across the globe and facilitated the assignment of expatriates to the EMEA and APAC regions, as well as the Americas. She has also provided training, functional direction, and insight to recruiters and hiring managers to help them transfer personnel at the global level. We are so thrilled that Sarah is able to join us. For those of you who might remember, Sarah gave some really great best practices advice for compliance last year. If you missed that webinar, we have the recording on our resource center, so be sure to visit our website and download your on-demand copy of that. It's just really great reference tool for you to use as you think about compliance and drafting an immigration policy for your team. So with that, I will go ahead and turn things over to Allison.
Okay, well, thanks very much, Brittany. Well, thanks for everyone for being with us today, and let's face it, compliance, it's intimidating, it's complicated. There are multiple layers of rules, limited resources, regulations, laws, statutes, lots and lots of moving parts. And it can really suck up the time that you have during the day and take away your ability to do other parts of your job. You're dealing with multiple agencies and then multiple departments within those agencies. In particular, Immigration and Customs Enforcement, United States Citizenship and Immigration Services, the Department of Labor, the Department of Justice. There's just a lot of things going on here. Even more complicated if you have locations and contractors that you work with and in different countries around the globe, well then immigration is factored even more into your workday. And of course, you're not only responsible for following the laws and the regulations of the United States, you're responsible for following the laws and the regulations of every single country that you are operating in. Consequences for violations not only include fines for an organization, but it can potentially impact your ability to sponsor foreign nationals in the future. Not only that, if there is a willful misrepresentation or an act of fraud made, an individual can face civil fines or penalties, even criminal charges if there's ill intent. So you're not only potentially dealing with minor disruptions in your work, you could be dealing with an end of your full immigration program if you're not making this a priority. So 39% of employers that we surveyed have had challenges maintaining accurate records for compliance. And because you're dealing with all these different agencies at all these different levels, it's really about time to make this a priority. Another reason why now is the time to make this a priority is because the last couple months have been interesting. There's been some changes, and April 2017 was particularly interesting. The Department of Labor, the Department of Homeland Security, and the Department of Justice issued memos announcing that they would start coordinating at a greater basis than they used to go after organizations that have violated the H1B program rules. Now, of course, previously these organizations would occasionally collaborate when doing investigations. However, generally investigations into the H1B program have been done by USCIS and the Department of Labor's Wage and Hour Division. Now, those organizations have been known to do investigations, and they do it occasionally if there was a complaint from a particular party and there was reason to believe that there might be a problem. Also, some organizations that were willful violators in the past may have received site visits or audits from these organizations. But what these April 2017 memos are really saying and giving you notice to is that we should expect greater investigations and greater possibilities of someone showing up at your door asking questions. Now, the good news is only an act of Congress can substantially change the H1B program. However, these individual organizations can add extra hoops to jump through, but right now we can count on the H1B program, materially speaking, staying the same as it is right now. But it's these extra hoops that can cause you problems. And so now is the time to check your records, coordinate actions, and make sure your documentation is in order. Now is really the time to act. This is your notice. These memos mark something very important, and now is the time to look inward and conduct some self-audits and hopefully implement some of these best practices that we are talking today. Now, it's important that your organization has a plan. Now, if an officer shows up at your door, who's going to speak with the officer? Who's not? What if this person's on vacation? What documents can the officer see? What can you offer? What should you refuse to provide? What legally can you refuse to provide? Who is going to call your legal counsel and when? What if there are multiple officers that arrive from different agencies and there's only one person you've coordinated to speak with them? What if they're asking for different things in different parts of a building? What if the documents you need aren't in your building? They're in a separate building. What if the officer wants to speak to a foreign national? What if a foreign national hears an officer is on site and wants to speak to the officer directly? What's your game plan? Some of these policies here are good policies to consider and some best practices. So if an officer shows up, you can have the confidence to welcome the officer in with a smile and not be worried. when you're going and you're drafting these types of immigration policies, you want to make sure that you're involving legal counsel on the front end. You want to get it right the first time. You want to act in good faith, but good faith is only going to take you so far if the legal counsel is not involved. You want to be considerate of all the different moving parts that we spoke about previously. There are a lot of different policies, and essentially, if you are not aware of how all these moving parts interact with one another, you might have a problem later on. So please go and reach out to your legal counsel on the front end. Now, a couple different types of policies to consider are what we have here on our slide. Right to work, I-9s and E-verified discrimination policies. How and when are these documents going to be tracked? When are they going to be filed? Who is responsible? Who's responsible for going back and maintaining these documents and records? When somebody's work authorization changes, or you have a foreign national move from a work visa to a work authorization document, vice versa, who is going to be updating these documents and maintaining them? Immigration sponsorship. Does your company sponsor non-immigrants, or do they also sponsor green cards? When a foreign national becomes eligible for green card sponsorship, who is making this decision? What employees are involved in this decision? What if the priority date for a particular person is not current, and this is not a short-term decision? This is something that your company is going to have to commit to for 10 or more years. How are these people being treated in relation to other types of sponsorships? These things should be committed to in advance so there aren't problems later on in your organization or claims of discrimination. Global mobility. How will you track where your employees are working abroad? What steps should be put into place to ensure that work authorization is maintained and the laws of the countries that you do business in are followed? It's incredibly complicated because every country has different laws. This needs to be carefully considered and planned with legal counsel in multiple different countries. So it's important to do that work up front. Public access files are something that we're going to be focusing on today because it frequently becomes a problem, and because we've had notice in April that this is something that we have reason to believe that the current administration is going to be focusing on. Now, public access files are required to be created for all H1B, H1B1, and E3 sponsoring employers. Now, with the public access files, they are created right away when a case is initially filed, and when the labor condition application is filed with the Department of Labor, that's when it's created. Now, these documents, these files, have to be made available if a member of the public requests them. Now, you don't have to actually provide a physical copy to that individual, but you have to make the file available for that person to see and capture the information, such as making their own copies or taking a photo. Now, when you go and you consider the public access files, often these are items that are neglected. They're tough to manage, they take up extra time, they take up extra space, and they're often an afterthought. Now, the good news is they used to take up a lot of space. As of last year, the Department of Labor actually made a clarification that said we can now start storing these electronically. Before this, there was some back and forth, and the directions from the Department of Labor weren't exactly clear. They have clarified we can now start storing these electronically. So the space issue should be resolved. If you choose to keep them in paper, you have the option of keeping them at your principal place of business or the place where your employee is actually employed and works. That choice is up to you. But whether you're keeping them at your principal place of business, where the employee works, or electronically, we recommend that you use the best practice of keeping your strategy the same for all files, regardless of what that is, and doing that across the board. With these good policies and repetition and good habits and diligence, you're going to save yourself later on if an officer shows up at your door. It's just getting into the good habit of doing things right away, updating documents. Especially as we're getting into the contents of the documents, maintaining these files takes some time and effort, and you want to set a timeline for yourself about when that will be done. Now, The contents of the public access file. Employers must create the public access file within 1 working day of filing the labor condition application. And what is included in that file is the rate of pay for the worker. We are going to include the certified labor condition application itself in the cover pages, a summary of the actual wage system used, the posting notice that it was posted to give the population at the work employment site notice of the filing, a summary of benefits offered to the U.S. workers and the H1B workers, and if there are multiple business entities under one umbrella organization, a list of those entities included as a single employer needs to be in that file. One further additional requirement is if a union is involved in the employment, there's special requirements that you have to give the union notice of the visa application that's being made. So documents demonstrating that that requirement was met should also go into that file.
Okay. Perfect. So Allison has just shared the basic minimum document requirements to be included in the public access file. I'm going to expand on those requirements a little bit and drill down on those because the change of an employer status can affect what has to be included in the file. So for example, because most employment-based visas are company-specific, changes in corporate structure can have significant impact in the context of immigration. Specifically for our purposes today, one particular example includes how employers must manage their public access files following a corporate restructuring, which could include a merger, acquisition, spin-off, etc. The list is pretty long there. In the case of a corporate restructuring, additional information must be included in that public access file. And the Department of Labor has provided a pretty complete checklist of exactly what employers need to include in this context to be fully compliant. And so, as listed in our materials, this should include a sworn or notarized statement by the successor entity accepting all liabilities of a predecessor entity. It should include a list of the H1B workers that have been transferred to the successor entity. It should include each affected LCA number and the effective date of that LCA, a description of the successor entity's actual wage system, and the successor entity's employer identification number. Now, these documents are required to be included in the public access files in the event that the buying entity or the resulting entity is considered a successor in interest of the original entity. And that's kind of a pretty complex legal determination. And so in doing that, we recommend that you partner with Immigration Counsel so that they can confirm to you whether there is a successor in interest relationship and whether these requirements do apply in your case. Okay. Additionally, employers who have been deemed to be H1B dependent or willful violators must make additional records available to the public. So these records have to be provided if the DOL arrives, or if any member of the public, as Allison said earlier, that public access file does have to be available if any, Joe, Tom, or Harry shows up on your doorstep and does request a specific file from you. Okay, and so what is an H1B dependent employer? At a high-level view, as opposed to going down into kind of the nitty-gritty of the regulations and the calculations that have to be made, an employer is considered H1B dependent if it has 25 or fewer full-time equivalent employees and at least 8 H1B non-immigrant workers, or 26 to 50 full-time equivalent employees and at least 13 H1B non-immigrant workers, or 51 or more full-time equivalent employees, of whom 15% or more are H1B non-immigrant workers. Now that last one that I gave you for the 51 or more, that can become a very complex calculation, and so we do urge you to contact Immigration Counsel if you are concerned in any way that you may be H1B dependent and get some tips on how to make that calculation. Additionally, what's a willful violator? This is a more complex definition than the kind of calculation for dependency, but generally it does require that an agency found an immigration violation and that's related to those LCA obligations. Essentially, if you are an H1B willful violator, you will know it. But in that case, those two types of companies must provide a list of H1B exempt workers and also a summary of recruitment methods to show that you have considered the U.S. workforce for that position if the employer hired any non-exempt H1B non-immigrant workers. Okay. So Allison mentioned earlier that a lot of employers can fall into some traps and make some common mistakes in trying to keep up with their compliance obligations. And as you heard today, we've really focused on the public access file. So what are some common mistakes that we see employers make with maintaining those public access files? One is over-documentation. As you see today, we've provided you very clear lists of the regulatory requirements that must be included in a public access file for your employees. You don't want to include more or different documents than what is absolutely required. You're opening yourself up for a potential violation or liability, or kind of in a more general sense, just confusion if the DOL arrives to review or a member of the public arrives. Piggybacking on that, a public access file is not a personnel file. You want to keep personnel files and public access files separate. As many of you know, personnel files can contain very confidential information about an employee, and because the public access file must be made available to the public upon request, you don't want to accidentally show them some confidential information or sensitive information that is not required. Okay. Another big one is creating the public access file and then forgetting to add the certified LCA after it is approved. As Allison said earlier, the public access file must be made available to the public within 1 working day of the filing of the LCA. Well, that gets really complicated because that necessarily means that the initial version of the public access file can't have a copy of that certified LCA in it because it's still pending. So employers should work with counsel or otherwise create their own ticklers to ensure that that certified LCA is inserted as soon as it's approved. And that can be a difficult thing to keep track of without a strong tickler system or strong technology. Another one we don't want you to forget is the failure to contact legal counsel when an officer shows up. That should be, and I'm going to drill down into this a little bit in the next slide, but that should be your first instinct. If an officer or even if a member of the public shows up, contact legal counsel, loop them in, make sure that you're in compliance with the relevant laws. And then the last one, which I'm also going to drill down a little bit more next, is maintaining all public access files that your company has ever created. There are very specific document retention requirements related to the public access files, and you don't want to maintain them for longer than necessary. So as promised, what are some of our best practices? As I said earlier, the public access file does have a very detailed document retention requirement, and so you should be keeping them for 1 year past the length of the sponsored employee's tenure with the employer. What if the LCA someone never showed up for work or you never used that LCA? In that case, you should still be maintaining the public access file. However, in that case, you should be maintaining it for 1 year after that LCA is withdrawn. We recommend this because we don't want employers to keep the public access files longer than regulations require, so that in the event of an inspection, if there are errors in that public access file, you're not on the hook for something that you didn't need to have in the first place. Okay. So a few more best practices, and this is a pretty long list. But essentially, what can you do as an employer to ensure good faith compliance and to be prepared in the event of an inspection or audit? Allison covered a little bit of this earlier, but I'd really like to drill down on that and then also let you know that your GIA attorneys are available for questions and can partner with you to strategize a response or put together a policy or plan for your organization. So number one, know what you're working with. Let's know what the health of your organization is when it comes to these public access files. Step one is performing an internal audit. And part of that audit is the very basic question of where are they? Where are your public access files? Where should they be stored? For your organization, does it make more sense for you to keep the public access files at specific work sites that relate to the employees that's being sponsored? Or is it better for your organization to store those centrally, maybe at headquarters or another location? That's certainly something that you immediately want to know. Additionally, ideally you would partner with an attorney to go through these public access files and determine the health. Are the documents that need to be in there? Are you in good shape if someone were to show up requesting them? Second step, after you know your state of affairs, have a plan. Designate an internal expert who has been trained on public access file requirements, and make sure that person has a backup in the event they are out of town during a site visit or during a big LCA filing push when those public access files need to be completed. Okay. We've alluded to this a little bit throughout the presentation, but use technology when possible to track the collection of the public access file documents. This recent guidance from the Department of Labor that we can be storing public access files electronically is really exciting and really does help employers and attorneys manage those public access files for you more carefully. Okay? Additionally, we kind of referenced this earlier, but consistency and standardization of the documentation and in that collection process is key. This is important for a couple of reasons. Before I mentioned that we don't want to over-document or include documentation in the file that isn't absolutely necessary. That's one step. The other step is to avoid any inference of discrimination. You don't want to be collecting certain documents for one employee but not for another and open your company up to that potential liability. Okay. Another part of this is setting those ticklers and reminders that I talked about a minute ago. As I said, it can be really difficult to manage including that certified LCA in the public access file when it's actually issued after the public access file is supposed to be constructed. Another thing that you might want to remind yourself of, Allison mentioned that a benefit summary is required. A lot of employers change their benefits annually. A best practice public access file would be updated with that new benefit summary as those benefits change. And so that's something that you can set a reminder for. And then having that plan if the officer or agent shows up at your front door without notice. And this also goes if an individual member of the public shows up. You would want to instruct your receptionist and or your security guards on how to behave if they do arrive and ask to review the public access files. You want to make sure you know exactly what they're asking for and you're not providing them with more than they have requested. Another thing we want to drum into you today is to contact your attorney as soon as an officer or individual arrives with the request. If an officer presents documentation, a copy should be provided to your attorney immediately so that they can provide you that holistic advice and recommendation. And then the other big piece of knowledge that I would give you is to document the site visit. Note the officer's name, note their title and their contact information for the company's records. As soon as they leave, document everything that they did while they were there. Not only can that help you manage expectations for future visits, but in the event that there are follow-up questions from an agency, you have a record of exactly what happened that day, what you provided, and what was discussed. In conclusion, this can all sound really scary, but you're not alone. Envoy and the attorneys at GIA are your partners in combating noncompliance. And you can contact your GIA lead attorney to develop a plan of action today.
Excellent. Thank you so much, Sarah and Allison. I know this has been a topic on the minds of a lot of people that we've been speaking with here, and certainly, you know, we see things about compliance pop up in the news every single day, so this is incredibly helpful. No surprise, we do have a number of questions from a lot of people. Some we did answer in the presentation, but I know there was a lot of information to digest, so we'll go ahead and go over some of those questions that people are asking. Again, if you do have a question, please utilize the question tool on the right-hand side of your screen, and you should be able to ask a question there, and it'll post to us directly. So, Sarah, Allison, here's a question that someone had specifically regarding public access files and H1B extensions. For the public access files, do we need to get a new one after an H1B extension is filed? And what do we do with the previous public access file we have?
Sure. I think best practice is generally to create a separate file. This is, again, where having an electronic system is really helpful. Why we suggest that and storing those together is to ensure that A, the document retention is occurring, but B, to know which public access file relates to which petition. The LCA is a very generic document with only like a little number at the bottom that's really differentiating it. So it's helpful to ensure that you know which relates to which petition. You would want to mark the initial file as the new file comes in with that kind of document retention requirement because it is specific to the underlying LCA. I don't know if Allison, if you have anything to add.
I think that's it.
Perfect.
Great. And one of our attendees would like to know, how long should you maintain an H-1B public access file for an employee who's been terminated from the company?
The regulations still require 1 year from that termination date.
Great, okay. Here's an interesting question. So going back to the LCA number that you mentioned just now, Sarah, someone would like to know, if an officer does arrive on site to conduct an audit, will they ask for a specific file by the LCA number?
In my experience, no. And frankly, in my experience, when the DOL does show up, they have a very specific plan of action in mind. And that can include asking for a variety of public access files, and generally there will be a date range, because as Allison mentioned at the outset, a lot of DOL investigations are complaint driven, and so they will often ask for the public access files within the date range related to that complaint. And the alternative, they would, yeah, that's actually all I've seen is the date range.
Yeah, and I think you have to keep in mind it's very expensive for the Department of Labor to send an officer to your particular building. So when they go, they're going to want to maximize their time there. So even if they're looking for a particular file with a particular name and LCA number, most likely you're going to see them going through whatever they have time to do within their limits and their particular guidance.
And I'd like to just piggyback on Allison's comment to say this is why it's so important that you do contact your attorney as soon as someone arrives, because in my experience, particularly if you receive an onerous document request, an attorney can successfully ask for more time within which to respond so that you're not alone providing that documentation immediately.
There's no such thing as a casual site visit. there really isn't.
If only it were that easy, right? So this answer, you just answered a question that somebody else had, but I do want to address just to confirm that we received it. So someone had asked the question about legal counsel. They're located in New Jersey, but they're their actual headquarters is in California. So how should I handle if an officer shows up? And Sarah, you had just mentioned, be sure to reach out to them right away. You want to call your attorney right away so they're aware of what's going on and can provide that advice to you over the phone.
And you know, that's a really good point. Something we didn't talk about is we said have that person who's going to be the contact person, have the person who's going to be responsible for speaking to the officer. Well, if you have different locations, every location needs to be grouped into that decision-making process and understand what needs to happen, because you don't know when they're going to show up, you know what location they're going to show up, and you need a point of contact for every office.
Exactly. Yeah, that's great. Great advice. Some more LCA questions coming in. If there are multiple LCAs for an employee, do we need to keep all of them, or do we just keep the most recent LCA?
Well, you're still required, if there's multiple LCAs, then there was some type of, it's either an extension or a change in employment or an amendment, and so you are still required to hold on to those 1 year beyond whatever the termination date is of that relationship with that particular employee. So you're holding on to all of them for 1 year until that person no longer works for you.
Okay, great. Here's an interesting question. So we had mentioned the H-1B employees or the non-exempt H-1B employees. What qualifies a non-exempt H-1B employee?
Sure. So this was in the context of willful violators and H-1B dependency. So that's a pretty delicate question. I think we have some collateral on that we could get to this individual, because I'd want the context as to why they're asking the question. That's okay.
Yeah, certainly. And maybe they could even ask more specifically in the communication center.
Great. And
their GIA attorney could respond accurately and appropriately to that question. A few more questions. Again, about the LCA. So it says the cover page on LCAs state that I must maintain a signed hard copy of this LCA in my public access file. How does that fit with keeping an electronic public access file?
That's a great question, and that is one that was stymieing immigration practitioners for years until the DOL came forward with this new information that we could store them electronically. The idea would be that you would scan a copy of the signed version and include that scanned copy electronically.
Okay, great. And just going back, I know, Sarah, you had mentioned, too, the difficulties in when you actually have to file the LCA and along with the public access file within 1 day, but it's not certified at that point, so really making sure that you're staying on top of when you receive the certified LCA. Someone had a question about whether or not you can still remove the non-certified LCA from the public access file, or if you need both copies.
Sure. The list that Allison provided that's in the slide is the final list, so I think best practice there would be to remove the unsigned copy for purposes of clarity and include the signed copy. What I don't want to happen is that if this employer is posting a copy of the LCA, which would be an unsigned copy because of the date it has to be posted, make sure you're not removing the posted LCA if you're doing that instead of just posting a notice.
Okay, great. So we've talked a lot about having the proper documents and having a process in place in case an auditor or an officer that's conducting an audit shows up on site. Someone did have a question about, what do we do, or what is the proper procedure if an officer shows up at a site and the requested public access file is actually not held at that site? What would you do at that point?
Well, at that point, it's hard to give an answer to that question because there's a lot of moving parts and a lot of factors on that. The first thing you need to do is you need to call your attorney. You need to call your attorney, and they will walk you through what steps you should take in that particular circumstance, because maybe the file isn't there because there's a mistake. Maybe the file isn't there because the employee isn't at that physical location for the LCA that you're looking for. And that would be fine. That would be, there's not necessarily a problem with that. Maybe the officer is there because their office is in Dallas, your headquarters is in Dallas, but all the employees that are sponsored are in a different location. I mean, there's a lot of different reasons why the officer could be there and the file might not be there. So that really nails in the purpose of having a plan, having a game plan, knowing what to do, knowing where things are kept, knowing what kind of responses you would give for an explanation of why a file isn't there, but also immediately looping in the attorney.
Great. Aside from the USCIS, are there other agencies, and I believe we did cover this earlier, but are there other agencies that could come by and ask for those files and conduct an audit to your organization?
Well, anyone can ask for a public access file. Anyone, any member of the public can ask. So that means any officer from any department could come and ask. So there's no requirements on that. But generally we're going to see the USCIS, Department of Labor, Department of Justice. Those are the ones that most frequently would be asking for something like that, but anyone could.
Okay, great. Are there any elements of the public access file that need to be retained after 1 year, after an employee is terminated or departs from their original role? Is there anything that we should be retaining as part of that file post 1 year?
From an immigration perspective, and assuming that all of the documents included in the file are those that must be required in a public access file, no. But for those employers that conflate documents or maybe slip an I-9 in there or slip other personnel documents in there, then that would have to be reviewed separately, which is why it's so important that the public access file be maintained separately.
And that's also a question to ask your general counsel also, because there might be other reasons outside of immigration law that some of those documents might want to be maintained. So that's a great question to give to your general counsel and not just your immigration counsel.
Okay. So when a benefit summary changes, do you have to file the new copy in all public access files or only the public access files created after the benefit itself changed?
Correct. So what I have generally done in this context is just create a master file to be used with the public access files. I will say that this has been reviewed by the DOL in specific employer instances and has been deemed to be okay. There is no official ruling, however, from the DOL on this. And this generally is defensible for larger employers. And again, this is just based on my personal experience, and there is no official ruling. But in that case, you might create a master public access file that includes that benefit summary that would cover all files before that date, and you'd include a memo stating why you've done that. Perhaps you have 100 public access files before January 1 of 2018 when that benefit summary changed, and then the expectation would be that any public access files created after the benefit summary change would include the correct copy.
And so again, just another example of different legal strategies that are going to work for different companies, depending on your size and how many foreign nationals you're sponsoring, and whether you should do something like that or not. Well, that's really an individual conversation you need to have with your attorney.
Exactly right.
Great. So do we need to maintain a public access file for L1A visa holders too?
No. The public access file is only required when a labor condition application has been filed, and that's only filed in conjunction with an H1B, E3, and then the H1B1.
Okay, great. And yes, there are a lot of questions coming in about whether or not these slides will be available. We will absolutely be sending this recorded session to you following the webinar, and then we will also be hosting it on our site under the Resource Center, where you can access the recording on demand at any time. So those will be coming your way post-webinar. Here's a great question. So, we've been talking a lot about electronic versus paper filing, and this person wants to know, so if we decide to move to electronic public access files, is it okay to leave the older public access files as they already are and then have all of the new public access files moving forward as electronic, or will we be required to update all of the public access files we have to electronic as well?
I think there's not necessarily a problem with leaving what you have in paper and then moving electronic going forward. I don't see any problem with that. However, it might not be the right decision for your company. I think that depending on the size and how many locations you have, there might make sense to go to electronic exclusively now that this option is available. But certainly there wouldn't necessarily be a problem maintaining what has been done in paper and then moving forward with electronic.
Great. So here's a question as it relates to H1B pay, and we've actually heard this a lot, and we've seen this a lot throughout popping up a lot. Do we need to update the public access file when there are comp increases? Do we need to include that information when that type of information changes?
Well, it depends on the situation.
Mm-hmm.
It really depends on the situation, because sometimes the answer is going to be yes, and sometimes the answer is going to be no. So we need to, whoever asked that question, if they want to reach out and post in the communication center and reach out directly and describe the circumstances that they're talking about, they'd be able to get a solid answer of whether something needs to be updated or not.
Okay, great. So during an actual audit, or when an official shows up on site, will they be reviewing all of the public access files at once, or what can be expected of that?
Sure, and I know Allison has had some experience with audits as well. In my experience, they generally ask for so many documents that they can't be reviewed all at once. And of course, in my experience, my former clients reached out in enough time for my law firm to request more time to respond, and therefore we had a very careful agreement as to when and where the documents were going to be produced, which is why we recommend that you reach out to your immigration attorney immediately so that you can put together kind of an agreement with that officer that makes sense for you. I don't know if Allison has had any different experiences with that.
I've had similar experiences. I would say also with smaller employers, you can expect to be asked to show everything.
Okay, great. Here's a question specifically. I know we addressed some of the issues that employers could face if they are in non-compliance, and being given fines is one of them. So someone is wondering if there are specific fines that are associated with violations of a public access file audit, or does that vary based on what the official has actually uncovered during their visit?
Great point. The fines for public access file violations are not as defined as those in the I-9 context. So those are not as clear. And you're exactly right. It really depends on what they uncover. And so it's hard to give kind of a blanket overview as to what fines might be related to an investigation in your company's case.
Okay. So if a Department of Labor officer shows up, would it be possible to have a request to them to return at a later date? And if you do make that request, is there a specific reason that you can provide for it?
I would generally recommend, and again, this is something that each company needs to confer with their immigration attorney. We did not include a disclaimer at the outset of this, but I should provide that now, that this is not intended to be legal advice. This is a general overview of the public access file requirements. So when you're asking those specific questions and want to implement them in your case, you really need to be consulting with your immigration attorney. However, in general, it's a good idea to comply with the officer, which is exactly why we suggest that you contact your immigration counsel. Perhaps the right response to the officer is, thank you so much for coming. If you don't mind, I'm going to contact my immigration counsel. Can you wait a few moments while I do so?
I agree.
So we talked about keeping the public access file post 1 year of termination of an employee, and someone is asking, after that time period is up, what should they do with the files? Should they be shredded? Do they need to be stored somewhere else? What is the best practice there?
At the 1 year mark, you can shred them. You don't have to keep them anymore. And really, it's a liability to keep them in a lot of cases, because if there was a mistake, an accidental mistake in one of these files, and it's spotted later on by an officer, that's going to result in a fine.
Great. Okay. So a lot of these questions, too, that are coming in are more case-specific, so we would definitely continue to encourage you to post these questions in the Communication Center to your GIA attorney. If we do not get to your question today, please feel free to reach out to us directly, and we will do so as soon as possible. Let me just pull, sorry, some of these questions are coming in. So someone asked specifically, since the file can be electronic, would Envoy be able to keep a public access file via our Envoy online account? If not now, maybe in the future? That is such a great question. Thanks for setting us up. Yeah, absolutely.
We are in the process of unveiling an audit tool and also a public access file storage platform or addition to our software platform. And I think the rollout date is it next month? So you should be seeing a lot of communication. We will roll that out with lots of bells and whistles, but that is something that's in final development stages now.
Great. Here's a question. So do you need a public access file for a TN? They do have an LCA associated with them. What do we do there?
No, a TN, you wouldn't be required to have a public access file for a TN visa.
Okay. Let's see, what else? So there are a lot of questions still coming in. Again, some of these are really, really case specific, so just continue to encourage you to post them to the Communication Center, and your GIA attorney can answer those directly. Here's a great question. So if an officer or an agent shows up at one of the satellite offices that a company has, should the employee designated to greet the officer first find out what they want before calling the counsel, or should they call their general counsel right away no matter what?
You know, I think it's fine if the person finds out why that individual is there, because the first question the attorney is going to ask you is, why are they there? What do they want? So I don't think there's any problem with that. I mean, I have very rarely had an experience that was negative with an officer. They're generally quite professional. They know that they're arriving as a surprise to you. They're happy to speak with your immigration counsel. I've never had any pushback at all with that. So they'll understand that you want to get legal advice and speak with your lawyer before you go into any in-depth conversations with them.
And to add to that, as Allison said earlier, there is no casual site visit. So if we are talking about a DOL officer or other agency officer, they likely have planned this for some time, and in our experience, generally will also have a document outlining why they're there and what they want to look at. So it would behoove you to also ask them if they've brought any sort of notice or letter or request for information, because you could then share that with your attorney as well.
And also just a practical tip, that is also, after speaking with immigration counsel, is a good time to cancel your meetings for the rest of the day.
That's good advice, definitely. So here's a question that's more looking at the trends that we had talked about, I'm not sure if either of you can really answer this question. It's really just based on what you've seen, but are there any certain industries that you've seen or that have been in the news as being prioritized by the Department of Labor to conduct these types of audits within, or has there been any spike anywhere in particular that you've seen?
In my experience, a DOL audit, specifically a DOL audit related to those public access files, is generally predicated upon a complaint. So the DOL Wage and Hour Division does have a hotline where folks can call in anonymously and leave tips or complaints. So in my experience, it is related to a specific tip. I do know that just in general, the administration has recently announced that it is going to provide more scrutiny on those employers that heavily utilize the H1B. I don't know that we've seen that in practice yet.
Correct, and also in this past April, USCIS created a tip email that if an employee or just a general person, or perhaps somebody who interviewed for a job and didn't get at the job, thinks that there's a violation or abuse or fraud within an H1B program, they can report that to USCIS directly, and that's new. That didn't exist before. The tip line for our Wage and Hour Division with the Department of Labor, it's not easy to find. It's kind of tough to find. A lot of people don't know it exists. The email for USCIS is actually pretty easy to find on their website, so there might be an increase in complaints in the future.
Great. Thank you so much. So I have a question. Do you have a process flow or checklist for an H1B application and LCA process that's available?
Yes, that's absolutely some collateral that we have, and if specifically requested after this presentation, we'd be happy to provide that to you.
Yes, absolutely. Not only do we have collateral that we can share, our blog is a really good resource for anybody who's looking to stay on top of the news, specifically about compliance. We've been, focused on this topic for quite some time now, so it is a really fantastic resource. We link to a lot of our documents and assets that we have available through our blog. So if you haven't already visited, it's definitely some really good content for you to share. And then again, we link to a lot of our assets there, as well as our resource center. So as I mentioned earlier on the call, our resource center has a lot of our past webinars on demand that you can download and access instantly. We also have ebooks and guides there for your convenience as well. And speaking of guides, we are putting together a compliance guide for everybody upcoming, and we'll be sharing that with you. It is really this webinar, and it's an expanded version of that. So it's really talking through how you can maintain immigration compliance and going through a lot of the things that we talked about today. So that will also be available soon, and we will be sharing that on the Resource Center as soon as it's ready. So definitely be sure to check out the blog and the Resource Center anytime you have any questions about this specifically, or certainly feel free to post in the Communications Center. Your GIA attorney can answer these questions. And we're, always willing to jump on a call and answer these questions as you have them. So, thank you again so much, Sarah and Allison. We know compliance is a topic that is just on everybody's minds right now. We really appreciate your time and talking us through all of these best practices and tips. As I mentioned earlier, if we did not get to your question, please feel free to send us a note directly or post to the Communications Center, and we will be able to answer you directly. We will be sharing these slides post-webinar, so if you have any questions or missed a slide in particular, they will be coming your way. So thank you everyone so much for joining us today. We hope you found this very valuable and useful, and we hope that you'll join us on our next webinar coming up next month. So thank you again, Allison and Sarah, for all of your wonderful insight. We really, really appreciate it.